one else tells you what to do.
But wasn't the original version life, liberty, and property, and then they supplemented happiness later?
There were some issues with property in pursuit of happiness. As you know, yeah, in the Constitutional Convention there's an issue with slavery. And there's a lot of debate there. There had to be some compromise in the wording, some of the concepts. And so property had to be kind of pulled out and pursuit of happiness had to be put in because of those debates about slavery, which would have broken the convention. Instead, they made those compromises to make that move forward. So yeah, this declaration wasn't debated in the convention, but the concepts are debated among the founders.
Is the Declaration of Independence part of the Constitution legally?
Good question. I think that's a debatable question. Article 7 of the Constitution says that this Constitution is ratified in the year of our Lord, 1787, September 17th, and in the year of the independence of America, the 12th. So 1787, counting back 11 years, because they're in the 12th year, takes us to the year what? 1776. Some people, law professors, they say, no, that doesn't tie it. I say, well, if the supreme law of our land, the Constitution, refers to the birth of our nation in the document itself, to me that's a direct tie. A direct tie in Article 7 says, we're talking directly about 1776. And what happened in 1776? The Declaration of Independence, the birth of our nation. There's some other court cases. There's a case in 1896 that talks about that issue and says it's always safe to interpret the Constitution through the eyes of the Declaration of Independence. That's back when the court was interpreting correctly the Constitution, right? But yeah, there's some interesting questions there. But yes, it's very much true. I believe, yeah, legally this tied very much to our supreme law of the land. Okay? Let's move on to the next little clause here. The reason I bring these up is these are very, very important. They're interesting and they're foundational, but they're very, very important to understanding property rights and how they work and how the basic foundations to who owns and controls property. Because this says that to secure these rights, governments are instituted among men. The purpose of government is to do what? Protect our rights. Okay? And I always provide two different words, protect and provide. Our declaration says the role of government is to protect, not to provide. So at a very high level, 10,000-foot level, if you look at something in this government program is providing, you say, well, I don't know, that breaches a very foundational principle. The foundational principle of the government exists to protect, to secure our rights. And it's interesting, it exists to protect our rights, not to protect the environment. Protect our rights, because if our rights are protected, we will protect our own private property, won't we, which is the environment. Okay? So it's not government's role to get involved in providential means. That's not what they're there for. Interesting. George Washington put this quote here. Government is not reason, it is not eloquence, government is force. Like fire, it's a dangerous servant and a fearful master. So not only is government's role to secure our rights, but government itself is force. Is force inherently bad? Is fire inherently bad? No, it can be used as a great tool. And government needs to have force. How are they going to protect our rights if they have no force to protect our rights? But government is force, and you need to remember that. So whenever government is used, it better be justifiable in our mind that force can be used. And force is always legitimate when we're protecting rights, but never legitimate when just providing or redistributing wealth from some to others. Force should never be used for that reason, only used to secure rights. Okay? Questions on that? Does that make sense? I think it's interesting. It'll get more interesting as we apply this to some private property issues. Lastly here, at least in this first part we're going to discuss of the Declaration, deriving their just powers from the consent of the governed. So government derives their powers from who? Us, the people. And not the collective people, but the individual person. If the individual person has a right to do something, that individual can transfer the power or authority to do such a thing to their agent, the government, to do in their behalf. But if an individual can't do something at an individual level, they can't delegate a power they don't have. If my neighbor has 3 horses, my other neighbor has 1, I can't say, I guess I'm the only equitable and socially just person in this neighborhood. You have to give one of your horses to them so you both have 2. And if you don't, I'm going to throw you in jail. Can I do that as an individual? If I can't do it as an individual, then I can't transfer the authority to do so to my agent, the government, because they only derive their just powers from the consent of the governed. from the government themselves. That's a very important concept. To me, that's the most important concept we can discuss tonight when it comes to property rights. At an individual level, can I use force to do this thing? If I can, great, then government can do it as well, because I can delegate to them that authority. But if I can't do it as an individual, I can't have government do it for me. That's critical to understand. Can I as an individual use force? If I can, then I can delegate to my agent, the government, to use that force in my behalf. Frederick Bastiat. Anyone heard of Frederick Bastiat before? He wrote a little book called The Law, and if you haven't read that, you need to read it. It's 90 pages. You'll open it to the first page and you won't put it down until you read it all. I promise, it's that good. He wrote a book called The Law, and in it he said this: "It seems to me that the rights of the state can mean nothing but the regularizing of pre-existent personal rights." What we're talking about, right? "For my part, I cannot conceive a collective right that does not have its foundation in an individual right. Hence, to know whether the state is legitimately invested with a right, we must ask whether the individual has that right in virtue of his nature and in the absence of all government." Isn't that what we're just saying? Isn't that what the last sentence there in the Declaration says? If I can do it as an individual, then that's the birth of a collective right. He's going to expand on this one more quote here. "If every person has the right to defend, even by force, his person, his liberty, and his property," and we do have that right, don't we? We have that natural right to defend ourselves, use force to defend ourselves, "then it follows that a group of men have the right to organize and support a common force to protect these rights constantly. Thus, the principle of collective right, its reason for existing, its lawfulness, is based on individual right." Okay, so we're trying to hammer this point home, and hopefully as we get through this, you realize, well, that's why we're hammering the point home, because when it comes to property and government involvement in property rights and property use and property control and property ownership, if I, as an individual, can control and use and stipulate what can be used as property, then government can do it. But if I can't, then government can't. Okay? And that's what he's saying. All right, so we're going to get into the Constitution here. Unless there are any questions. Any questions so far? Okay. I don't know if this is as exciting to you guys as it is to me, but I like this stuff. I think it's cool. Okay, to me, Fifth Amendment is very much full of property rights. To say that the Constitution doesn't talk about property rights is to me, I don't understand how you can't see this. Okay? Let me ask a question first of all, though. With property, is ownership or deed, if you hold the deed to a property, is that all that ownership is, or is there any other element to ownership of property? What if you hold the deed, but the government tells you what you can and can't do with that? Do you truly own the property? No. And in my mind, at least, deed versus use, the use is actually more important. Because I could care less if the government owns the deed and they let me do whatever I want to on the property, then I own it more than they do, don't I? But on the opposite, that's what happens nowadays is, we have the deed, don't complain about it. Well, no, I am complaining because I do own the deed, but I don't have any use of the property. So there is a confiscation of my property rights there. So Fifth Amendment says this: "No person shall be deprived of life, liberty, or property." We're going to focus on property. "Without due process of law." Okay, so it's not just the ownership, not just the deed, it's the use of the property as well. And Madison says this: "Property in its particular application means that dominion which one man claims and exercises over the external things of the world in exclusion of every other individual." Isn't that what private property right says? It's mine and it's not yours. That's the whole point. Now he goes on to qualify this and says, look, it leads to everyone else the like advantage. I'm not saying no one else can have private property. I'm just saying my private property is my private property. And your private property is your private property. Okay? "He has an equal property in the free use of his faculties and free choice of the objects in which to employ them." He can do what he wants to with his private property. That's what we're saying, right? The use. The use is so important. It's too often when we think about property, we think about I own the deed. But can you control the use of that property? That's the real question. That's what really matters. And that's where government tends to get involved and say, oh, no, we're going to regulate that. We're going to do this. And we should say, you're infringing on the ownership of my private property. But they say, no, you still got your deed. Don't worry about it. Sit back down. Okay? Okay, so we're going to talk a little bit more about the Fifth Amendment, but I wanted to clear something up first, because we're talking about the free use of our property. Nowadays, when you buy property, you're buying the zoning that comes with it, aren't you? There's no question. And you can't buy some property and then say, that zoning infringes on my property rights. I can do whatever I want to do. No, because you entered into a contract. When you bought the land, you bought the private property, or bought the zoning with it. Does that make sense? Okay, so it's a fallible argument to say, I can do whatever I want to. It says right here. Well, no, once you entered into that contract that had that tied into it, the zoning laws. What I want to argue, though, is that zoning laws violate natural law in the first place, okay? Because as discussed earlier, if I don't have the right to use force to tell someone what they can and can't do with their property, then I can't delegate to a planning and zoning commission, to government, my agent, the ability to tell someone else what they can and can't do with their property, okay? Now, we live in the world of zoning. I'm not saying we're outside of that. I'm saying simply that the concept, at a theoretical level, zoning violates that, because if I can't tell someone what you can do with your property or can't, then government can't, okay? So, look at this a little bit more deeply. No person shall be deprived of life, liberty, or property without due process of law. According to the Fifth Amendment, no person shall be deprived of the use or ownership of their property unless they've had their day in court to defend themselves and they've been accused of violating someone else's rights. In that case, they can have their property taken away from them. They can be fined. They can have things happen, have restrictions because of their actions that have restricted someone else's rights. But only if they've done that. If they haven't acted and violated someone's rights, then government has no reason to act. When government proactively acts, that's when we get in trouble, because then they start to restrict use of property. And this says clearly, you can't be deprived of property without due process of law. If you haven't done anything wrong, you shall not be acted upon by government. Okay? Let me ask a couple interesting questions here. So if you're using your property as you please, are you infringing on your next door neighbor's property rights? Could be. Okay? But if you're just taking care of your own property and doing what you want to with that, you're not necessarily acting on anyone else's property rights. And if their property rights are secure, then government shall not act. But here's the big question. Richard's kind of inferring this. What if someone is using their property in such a way that it's affecting the value of my property? What if my next door neighbor is letting their house completely go to shambles and it's all full of weeds and they've painted the house neon pink? Is there any question that's affecting the value of my property? And that's where it gets sticky, right? That's where it gets really sticky. You go, well, now what? Now, do we just throw out all these principles of freedom and we go, okay, government, you need to come in and fix this? I would say what we need to do is we need to look back to the principle. The principle is, what do I have the ability as an individual to do? If my neighbor, this trashy neighbor, is living this way, what are my options as an individual? What can I do? As an individual, what can I do? I can move. Buy something. I can go over there, literally, my option to go over there, knock on that door and say, sir, what you're doing is affecting the value of my property. Is there any way we can work something out here? And if they say, no way, then I can try the next day and say, hey, this is affecting me in such a way that I'm willing to put forth $500 on a whole entire Saturday to come clean up your yard, paint your house, and we can work through that as an individual, can't we? But do I have the right as an individual to say, guy's on vacation, there's a bunch of trash, I'm going to go in there and I'm going to burn all his weeds, I'm going to take all of his antique cars, we all know there's trash, I'm going to take them and throw them away, and I'm going to paint his house an earth tone, because I like earth tones. Can I do that as an individual? No. So can I transfer to government the power to use force that I myself don't have? What's that?
You can have the city government say, we don't want you to do this, and then they'll say, there's a couple of places in Jackson I'd like to do that with. But yes, you can say, okay, and that goes with the zoning, and that goes with trash, that's health, concerns, children's concerns, all kinds of things.
Okay, so theoretically though, do I have the right as an individual to make my neighbor do something that doesn't comply with my desire, my preference? Theoretically, no, I can't use force on them. Okay. Now you brought up an interesting point with health. Yeah, if there's a health concern or a safety concern, then what do you have? What you have is the opportunity to seek redress in a court of law. To say, look, I can prove that there's been damage, there's been a violation of my rights, and I can prove that in a court of law, and there will be redress, and there will be stipulations made at that point because it's related to health and safety. But if it's just related to a preference, I don't have I don't have any right to use force to act on my neighbor to make them do certain things that I like or don't like. Now, that doesn't sit well with some people. It doesn't sit well with me, really, quite honestly, because I want to have this house next to me not devalue my property. But guess what? Freedom is risky business. Freedom is I can trip and fall and skin my knee, And freedom is I can go run a marathon and win it. But freedom is not a guarantee. Benjamin Franklin said, look, there's a difference between security and freedom. You can have one or the other. If you want security, you're going to have to give up your freedoms to get that. If you want freedom, yeah, you may not have a safety net. You may just work through this thing. So what happens if I live I'm in a home and I want to control, I want to have some type, I mean, what I do is sit in my house and let everyone completely destroy the property of my value, or the value of my property? No. You have different things called CC&Rs, codes, covenants, and regulations. You have different zoning that can happen. And here's my philosophy, my idea, is that can be negotiated with individuals. People can talk about that. If you want to make sure a pig farm doesn't come in next to you, then before you buy that property, make sure that the area is zoned that way. Make sure that area has CC&Rs that work that way. And the individual owners of these different land can work through that decision together as individuals. Instead of saying, well, I moved here and I don't want that to happen, so government, you come and fix it. And then what happens? Government comes in and has two different people, two different opinions to deal with. And government chooses the winner and government chooses the loser. And there's some power involved there, isn't there? And I would argue that it's not legitimate power, because as an individual, if I don't have power to do something, then I can't transfer to government the power to do that myself, for myself. Okay? Kind of an interesting thought. And I know there'd be dissension. I know people say, well, I don't know. So throw some questions at me. What do you think? Jonesy?
I totally agree with the concept and the thing. Where it comes to a subdivision, when you go into a subdivision and you buy a piece of property, the codes and covenants and regulations are already set there, and you buy it knowing full well what those covenants are. Therefore, you don't have recourse to go back and say, no, I don't like it.
Correct.
I don't like that.
And that's what I'm saying. Beforehand, before you purchase the property, you have to understand what use comes with that property.
But if planning and zoning, sets a code or covenant or regulation for your area, and it wasn't there when you went in there, then that should be an ex post facto.
That's the next part we're going to get to here. Richard, did you have a question or comment?
No, that's it.
Okay. So you guys, those who are saying, oh, I don't know, just bear with me. And if you don't agree, that's fine. It's America, right? You don't have to agree with me. I think it's interesting stuff to think about, though, to try to go, huh. Because we live in a world where we expect government to come in and impose regulations. We live in a world where we expect government to come in and push these zoning rules. CC&Rs are developed by a private developer who says, this is what the standards I want for the piece of property I'm going to subdivide and sell. And that negotiation is made between the private seller and the private buyer. And if someone says, look, I have this property for sale, but I don't, and then the buyer says, well, I don't want this, this, and this to happen, what's going to happen to the price of that property? They're going to say, well, I'm going to raise the price then. If you want these certain restrictions, then I'm going to raise the price. And my argument is the private market can set their own regulations on land use. Why does the government need to come in and say, this is how it shall be? Why can't the people themselves, why can't the private citizens talk about land use, restrictions, etc.? Because otherwise, to me, that's shortcutting. Well, I don't like this, I'm going to have government come do it. Who's to say that they side on your side and not the other person's side? Okay? Getting into this contracts clause, and this is the point that I think is important. Article 1, Section 10, Clause 1. Let me get up here. Where's that arrow thing? No state shall pass any ex post facto law or law impairing the obligation of contracts. Okay? What's an ex post facto? What's that mean? After the fact. So if you get into some property, the next thing you know, someone's using their property the way you don't want them to, but it's completely within the CC&Rs, and you say, I don't like that, and neither do 9 out of the 10 people in my subdivision, so we're going to get government to come and make that person change. That, by definition, is an ex post facto law. Okay? Government's job, according to Article 1, Section 10, Clause 1, isn't to make the terms of the contract. Government's job is to enforce the terms of the contract. And why is that? Because at an individual level, can I go to someone and make them enter into a contract they don't want to enter into? No. So I can't give government the right and the power to do that. But as an individual, can I make someone comply with previously entered into contractual terms? You bet I can. So therefore, I can delegate to government the ability to do that. Okay? So the government isn't impairing the obligation to contracts, and government isn't making the terms of the contract. It's simply protecting the rights of individuals who've entered into contracts.
What about changing the covenants on a property, say the majority wants to change the covenant because someone is doing something that they don't like?
Usually in
The majority, is that still ex post facto and they can't force that owner to comply?
when you're talking about CC&Rs, usually that's a pretty simple concept because the CC&Rs have in their bylaws the terms to change it. And so if the terms say if a majority of landowners want to change the CC&Rs, they can. That's not ex post facto. It was written into the original contract that everyone signed into. That's fulfilling the obligation of the contract. It's not changing it. It's part of the original contract.
Add something that that person didn't buy into?
They did buy into it because when they bought the property, they bought the CC&Rs with it, and in the CC&Rs, if they read the fine print, it's right there. It says things can change with this process. Let's say it's majority rules of the current landowners. They did buy into that. It isn't an ex post facto law because they entered into that contract willingly to get that property. And even though, yeah, they may say, well, now you can't park your big Winnebago up front. Actually, that was part of the stipulation when you bought that. You knew those rights could be taken away because they're just granted rights. They're not inherent rights. They're just granted rights that were decided on by a group of people. Okay? Like I said, this tends to get a little philosophical. We'll get into some more fun stuff in a second, but okay. Now, moving on with the Fifth Amendment, because this is the part we haven't hit yet. Nor shall private property be taken for public use without just compensation. And too many people look at Fifth Amendment and just say just compensation. As long as someone's justly compensated for the property, government can take it, the public can take it. But I want to look at three issues that I think are two issues, more issues in this Fifth Amendment. The first thing is the term public use. Okay? We all agree, like you're saying, there's some downtown buildings in Jackson that just look horrible. They're horrendous. They're just an eyesore. We all agree that it'd be nice and it'd be good for the public if we could just rewrite some beautification codes and rip those things down. Okay? And let another developer have a little bit better taste or something. It makes something look nice. It would help our community look good. Okay? Is that public good or is that public use? That's for the public good. And the Fifth Amendment doesn't say you can do those things for the public good. The Fifth Amendment says only for public use. Is there a difference? There's a huge difference. A public good is just a matter of opinion. A public use is necessity for the public to use certain things, and usually that is utilities and roads. Okay, things that the public needs in order to function as a society, as a town. Okay? So the public use is a different term. The last one here, there it is. Another question, what about street front property owners who are forced to get up the 10 feet of their property front so we can have bikeable or walkable or nice landscaped streets? Is that protecting someone's rights or is that providing amenities? I think that's providing amenities. I think there's some challenges there because what's it doing? What it's really doing is stripping private property rights of the private property owners who have the property on that street. Okay, and just compensation I think is really a really cool term. It's pretty simple. If the public is going to take property in the form of land from someone, then the public has to give property in the form of money back to that person to make them whole. And the key is just compensation. Not, oh yeah, well, we've had this appraiser for years who continues to get these government contracts because they always appraise these property really, really low. We love them. They're great. Just compensation, to make them whole again. Okay? Any questions on that? Richard?
When you look at this, you see all the abuses that are going on right now, because I look at the term taken, very subjective term, which is used horribly. Just compensation, what is just?
Mm-hmm.
It's just the abuses with that. I mean, part of the bundle of rights are the economic rights, and you can do, as everybody knows, you can have a taking without the deed passing, which is part of what we're dealing with in the LDRs.
Good comment. The Kelo case comes to mind. I don't know if anyone knows about the Kelo case in Connecticut. Yeah. Yeah. Oh, did you? Okay, well then you're the pro on that, but I'll just simply say that in the Kelo case, essentially the Supreme Court said, no, public good is all right. Not public use, just public good. what we're going to do is we're going to take this private property from this person because we're going to bring in a strip mall. Okay, so there are 10 or 12 people, let's say, who lived in this area that they wanted to put a really nice business in. 11 of the 12 said, yeah, that's fine, but one said, no, I don't want to go. And they brought it all the way to the Supreme Court, and they said, no, you have to go, because if we get you out of there, we can bring this nice big business who's going to bring more taxes to the county.
And that's what they did it for, is to get more.
That's exactly what it is. And that's not public use, that's public good. That's for the good of the public, not for the use of the public.
What happened was Pfizer walked out when they were left.
They never built there, did they?
Poor people who got kicked out of their houses.
Yep.
Wasn't it based more on the idea that the state constitution more so allowed it than the federal constitution?
I don't know the details about which was allowing it, but I know it was an interesting case because it established this precedent of public good versus public use. And all of a sudden we go, wait, the Fifth Amendment says public use, but now the Supreme Court says, no, that means public good. I'd say, no, it doesn't. Okay? Yes?
What do you do with places like Pinedale and so forth, where the mining and the gas companies move in, and this is supposed to be for the country's good, for new energy, so we're not depending on Middle Eastern energy and so forth. And a lot of people there say, you're affecting our water, you're affecting our air. And I just drove through there recently, and the first time I smelled them, I said, wow, this is not for the good.
So what you're referring to, I think, is when these companies come in and they affect the health and safety of the community, right? In my simple mind, I'm not a lawyer, but in my simple mind, that it all falls back to, can you prove a health or a safety issue? And if you can prove that in a court of law, then you can seek redress and have stipulations put on them. But if you can't prove it in a court of law, you don't have the proactive right to say, hey, you're a business and you may pollute the air, so you can't come in here.
But you know what the main problem is that people don't have the money to fight these big companies. So then they're stuck in legal transactions for 14, 15 years before anything's done. Then when they've got their profit, they leave.
Yeah, good point. Yeah, and a comment, I don't have a response to that, but I do have an answer, and I was going to mention this when Richard made his point. When John Adams said our Constitution is made only for a moral and religious people, it's wholly inadequate to the government of any other. No amount of laws can force morality, can force virtue. It has to be internal in the person. And so when you have an immoral, overbearing, crooked industry coming in, etc., no amount of laws can force goodness. And so you have to... Go ahead.
Can you repeat the question? We can't hear the
Oh, yeah. Let's see. Question, the most recent question, thank you, is, okay, well, Pinedale, wondering about, if they have the big corporations that come in and try to say, well, we're going to do this, and they end up destroying the air, or the water, the environment, etc. What do you do in that situation? So I gave that answer there. I don't know if it's sufficient, but...
But the whole point is, the people that lease the ground, that drill for the oil, they have property rights in the minerals, and then the surface damages, if they, I'm not saying it's all right. What I'm saying is they're exercising their private property rights, and the idea that we have a state government, DEQ, or whoever to regulate it so it doesn't get out of control. Like I say, it's one man's, when they smell the oil well, it
smells like money.
It's money in their pocket, but the rest of us, and then they're truly,
So
working on the idea of the ozone, and that the common thing, that true health and safety. I mean, I see it as it's needed, of course, but they still have the right. You say corporate profits, well, they're owned by people that are buying stock in their company and then putting gas in your tank. I mean, it's all part of the system. Everybody can't just pick out what part of the world they want to be pristine for themselves.
Yeah. So the comment was made, essentially. Those businesses are exercising private property rights and mineral rights and extracting the resources from the ground. So, and then we have a state DEQ, etc., to regulate and make sure that they aren't violating the health and safety of the citizens. So yeah, there's some interplay there, isn't there? There's some private property issues that go along with that.
Do you see a departure from the earlier principle you talked about here? If I am a private person and I want to use my neighbor's property, may I use force to use his property? No.
Correct.
This seems to be saying that the government may do so. Am I seeing that?
That's how I read it. Yes, because what it's saying is private property shall not, property shall not be deprived, except under 3 conditions. Government can deprive people of their private property. The first condition is due process of law. I can take property from someone if they violate someone else's rights. Second condition, if the public needs to use that private property and it's for public use, truly for public use, they can take that. Thirdly, they have to justly compensate them. And I don't see those as 3 different things. I see those 3 different things you have to check off. Once you get all 3 done, then they can take property. This says takings. They can take property if, first of all, to punish for due process of law, but secondly, if it's for public use and it's justly compensated to do that. But the public use to me is the big offender. Too often it's public use. No, that's just public good, or that's just something someone wants or wants to develop, or no, it's not about private interest, it's about public use. And I think the founders looked at that public use as, regrettably, we need to take this private property, but because we're going to justly compensate you for taking your private property. And I think that's exactly what Amendment 5 is saying, when they can take property.
My family had a situation, 10 or 15 years ago. We had a ranch north of town, and 2 of those things happened to us. Private property was taken for public use, that it was without just compensation. And what happened is, my grandparents both homesteaded here in the late 1800s, and they gave an easement for surface traffic to pass through the ranch. And then here 15, 20 years ago, why they decided they wanted to run a sewer underneath the road. Well, we hadn't given that easement.
Mm-hmm.
And the local county government here sold an easement that they didn't own for that sewer. And it went to the Supreme Court, and we lost. And we didn't get anything for it.
Yeah, there's a challenge there. So in summary, what he's saying is there was a private taking. There was an easement that was agreed to for surface traffic. Then it came down later on the line, the government said, oh, we're going to use that easement for a sewer line. Well, the easement is never there. The government sells the easements to surface traffic for sewer lines. They take an easement they never had and sell it, and don't justly compensate the landowner. That's a violation. And the fact that you took it to the Supreme Court and they ruled against you is in my mind, simply wrong.
Well,
but based on constitutional concepts too, not just based on, well, that's not fair. It's based on contractual law. And they violated Article 1, Section 10, Clause 1. They impaired the obligation of contracts. They're taking without justly compensating. I think there's ample evidence to prove that otherwise.
Which brings up the interesting point. What do we do about courts who usurp the authority to determine what the Constitution says? That's the root of us losing our freedom right now, is they'll take that and they'll say, well, public use means public good. They can't understand plain English. So these people sit around with black dresses pounding a wooden hammer and rule our lives.
There's interesting, it's a great question. And constitutionally there's a solution. And it's not, the issue isn't the Supreme Court's out of hand. The issue is that people don't understand what the Constitution says. Because the Supreme Court is out of hand, but there's always constitutional checks and balances. At the break, I'll look at exactly, but I think Article 3, Section 2, Clause 5 says Congress can limit the appellate jurisdiction of the Supreme Court. In other words, Congress can say, you're wrong, you ruled wrong, and we're no longer going to let you rule in that area. They can do that. Too many people say, whoa, that's not constitutional. Well, actually, by definition, if that's what it says in the Constitution, that is constitutional. So Congress can do that. It hasn't been used. It's been proposed over and over. It's been proposed the last 15 years by a representative called the Sanctity of Life Act. For the last 15 years, we were going to limit the appellate jurisdiction of the Supreme Court because they ruled wrong on abortion. We're no longer going to let them rule on abortion. We're going to make it a state issue. But how many of us heard about that? Even knew that was in the Constitution, or much less knew that provision was out there and that people were shooting for that. We didn't hear it. The media controls what we hear.
In you know, nowhere in the Constitution does it give the Supreme Court the right to rule on what the Constitution says.
Correct.
Marbury versus Madison in 1803, the court usurped that right and said, we will be the ones that decide what the Constitution says. But Carter Coal Company, the Supreme Court ruling in Carter Coal Company said the Constitution is written very plainly, and any person with common intelligence can understand what it says.
I forgot. Right.
Right.
I forgot to reiterate the first question you said was, how do we control a Supreme Court that's out of control? And that was the answer. Now your comment simply is, they are never given the right to rule on what the Constitution is. It's pretty clear in Article 3, section, I do a whole presentation on this called Checks and Balances, but in Article 3, and I can look at that in the break as well, I think it's section 3, very clearly says over and over, their jurisdiction is the case, and then it says controversy, and it says case. So the jurisdiction of their opinion, because what do they issue? They always issue an opinion. The jurisdiction is to that case. They don't have the right to write law. Article 1, Section 1, Clause 1 says, all legislative powers herein granted shall be vested in a Congress. How much does that leave over for executive to make laws? How much does it leave over for the judicial to make laws? 0. So the constitutional provisions are there. Their answers are there. The checks and balances exist. It's our lack of... What's that?
They're not being used, though.
Not being used. And the challenge is it's not just the general public who don't understand about that, but it's also Supreme Court justices who don't understand about that. It's a challenge. Okay? I don't know why they'd advocate that check and balance, because that would diminish their power. I don't know why lawyers going through law school would learn about that check and balance, because it would diminish their power. Let's talk about case law. Let's talk about precedent. Let's not talk about what the Constitution says that can limit what we can do. Let's talk about case law that further substantiates our existence and our decision as being the basis of what the Constitution means. And it very clearly says the Constitution, or the Supreme Court, is to rule on the law and the fact, not to rule on the Constitution. They're supposed to judge the law and the fact against the Constitution, not judge the Constitution. It's clearly written in the Constitution itself in Article 3.
Where do we find the health and safety justification for the government's taking powers? I've used that phrase several times. I'm wondering where you find it.
I don't know. That's a very common term in national, state, local level. Where I find it is right there in the Fifth Amendment, where it talks about being deprived of life, liberty, and property. If someone's actions are depriving you of your life or your liberty in the form of health and safety issues, I think there's a legitimate function for government. Now, is there an overexpansion of the term health and safety? Yeah, you bet. I think so, yeah. Oh, that's my health, that's my safety. I have a right to that. You have a right, you have a God-given right not to get sick? Really? Not that I know of. Okay, so there's some implications there as well. Just to say, well, just because I'm sick, someone's violated my rights. I got a really bad cold last week. That doesn't mean somebody violated my rights.
You have a right not to be sickened.
Sickened, there's a difference, yeah.
Yes.
Yes, so health and safety, that's where I think the judicial stands to say, look, can you prove in a court of law you can seek redress and therefore you can get actions mandated by court, court orders. Okay? Go ahead.
I had a situation living in Colorado, and we were renting a house from a fellow who was using our rent to pay his mortgage on. So we took it to small claims court. And while we were there, the judge says, oh, well, we're giving this to this man, you have no reason to be paid your money. And that included our last month's rent. Well, he had a liver problem and he was up for a liver transplant. So he comes to the conversation with the lawyer, the mediator, with a bag full of drugs. And, that could have said something else too about the guy. He was on drugs a lot. So anyway, what happened is the judge, during the procedure, says, well, this is for the case such and such and such and such. Well, I was in school when my stepfather was going through law school at YO, and I learned a lot. And I said, I don't believe that. So I went back and looked it up. It had absolutely nothing to do with the case. That guy thought he could get away with just
spouting some statute. Yeah.
And that's the problem.
Yeah.
The biggest problem today is people are trusting too much. You've got to get off your butt and go check it out yourself.
Yeah. And I agree. Essentially, the example was given that a judge quoted incorrectly a statute to justify this thing, and it had nothing to do with the issue at hand. To me, that's part of the challenge of like what Jonesy's referring to. They're getting so deep in the jargon Well, we have some really simple terms. That's what the Constitution is all about. It's some very simple concepts of freedom and principles of liberty that you follow, and they'll guide you. And you do that, and you're fine. But you get into all the jargon and, you know, 10 layers deep into all this stuff, and that's where you get away from true principles, and you're more worried about complying with the dotting the I and crossing the T rather than the true principle that's there in the first place.
It's called legalese.
Legalese.
Can't get a judgment. You know how?
Yeah.
What is, there's the best. I like that.
How many semantic issues do you find within the Constitution, Declaration of Independence, like even the word use, that there becomes this argument as to what indeed is the definition of so many words that are within the Constitution?
Well, I would say hundreds and hundreds and hundreds and hundreds of Supreme Court cases say that that's how many, hundreds upon hundreds of semantic questions. And what happens, the way to fix that constitutionally is the Supreme Court makes a judgment, and the way that the judicial branch says, well, that established precedent. So now everything will be based on that precedent. That's not true. They make an opinion for that case, and at that point, Congress has the choice, because everyone's make law, they have the choice to write a new law that says, that legislates a new law that complies with that opinion of the Supreme Court, substantiates it, or they have the right to exercise in Article 3, Section 3, whatever that is, to say we're no longer going to let the Supreme Court rule on that because they ruled wrong, and we're the ones who make the laws here.
And that has never happened?
Not to my knowledge. Kind of a radical idea, a radical constitutional idea. Okay, let's get moving here. Good questions. Quite simply, this is the point that I made with the earlier question. I forgot your name. Shepherd. It was Shepherd was saying, yeah, that's essentially what it is saying. Yeah, government can take private property in the process of law, of you violating someone else's rights, when it's really public use, and therefore they justly compensate you for that. Okay? Now, to me that's full. The Constitution is full of property rights. It talks about it over and over and over. All these different words in the Fifth Amendment, all these different things we've discussed, right? Another one that's very, very clear is the federal land powers. Article 1, Section 8, Clause 17. This is very clear. The only power that the federal government has to own land is stipulated. Article 1, Section 8, Clause 17. It says this: Congress shall have power to exercise authority over all places purchased by the consent of the legislature of the state for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Let me point out one thing. This little ellipse right here, what's in that is where it says it has jurisdiction over Washington, D.C. We know that. The federal government has jurisdiction over those 10 square miles. But then it goes on to say 3 stipulations. The first one is, has to be purchased. If the federal government wants something, these are, once again, 3 check marks. They have to have all 3 in order to do it. They have to purchase it. They don't just take it. They have to purchase it. And the legislature of the state has to consent to that happening. And the only reason they can purchase and the legislature can concur to do so is for 5 things. They are forts, magazines, arsenals, dockyards, and other needful buildings. Why? Well, because how's the federal government going to provide the national security if they can't have a fort in Arizona or a dockyard in Seattle, right? They need to be able to provide that. It makes sense. They can do that. But that's all they can own land for. That's all. It's right there. Okay, so anything in there's national parks or what do we got? Wetlands, preserves, scenic byways? No, it's not there. Intentionally so. Why? Because when the government gets involved with ownership of land and use of land, the government, by default, will choose winners and losers. And the free market can no longer choose. You no longer have supply and demand and profit or risk and reward governing private property. You have the government saying, you win and you lose. Why? Because we're government and we have force. We'll tell you what to do. So you can see why they said, keep out of this. Government's only job is to enforce contracts and to protect the rights of those who own property, not to determine who should and who shouldn't own property. Conservation easements, anyone heard about conservation easements before?
Oh, yeah.
Kind of interesting. Conservation easement essentially says, look, the deed stays with the person. You still own the land. The government's just going to pay you so that you don't use it for certain purposes, or you only use it for certain purposes. I have a problem with that, because remember, ownership of property isn't just the deed, it's the use. And when the government comes in and says, you can keep the deed and we'll control the use, in my opinion, they're violating Article 1, Section 8, Clause 17 that says you can only own property for forts, magazines, dockyards, arsenals, and other needful buildings, and that's it. So when they come in and control that use, there's a challenge. And the second challenge I have with conservation easements is where's that money come from? We're $16.5 trillion in the hole. Where does it come from? The federal government money tree? Or
I think, and certainly in this state and most others, conservation easements come through the private money, not through the government. The government, this is the myth that has been promoted, that the government owns that easement. Not so. It is it is a private transaction with buyer and seller agreeing. It's a contract which has no government, U.S. government or state government implications.
so who owns the conservation easement, like Ducks Unlimited and things like that? Is that what you're saying, or?
It could be the Jackson Hole Land Trust.
Great.
They own that easement and are charged with a stewardship of being sure that the person who owns the deed complies with that easement. The easement goes with the deed.
So there's a private contract that's entered into between two private parties. That's completely legitimate. That's what private property owners do. But there's no question. I don't know about what percentage, but there's no question. There's conservation easements that are given by federal government and entered into by federal government as well. And those are a challenge because then the federal government is participating in ownership of land.
They should be, but in general, the Nature Conservancy, the Jackson Hole Land Trust, the Wyoming Stock Growers Association,
Teton
all
County
private
Scenic
money.
Trust will give easements as well, and that's government.
And that's government control. Yeah, part of the challenge too, with these different conservancies, most of them, I don't know, most of them, what I've seen, and with my own eyes or whatever, when I've talked to private property owners, a lot of times the one who ends up with it will be Ducks Unlimited or a conservancy or whatever, but the one who initiated it was the government, and the government sold it to the individual. So a lot of times, I'm not saying.
But then who's paying the taxes on it, or not paying the taxes? That's a benefit of the public, so I mean, it's mixed up the rights. If you got the rights to do it, but you're not paying your fair share for having the rights, and they take it off to the side as a quasi-government deal. I don't know how it's all structured myself, but I'm just saying that, in essence, it's almost like government control because it's a nonprofit or whatever, and it's a private contract, but yet if they're taking the value of that out of the economy and they're not paying taxes on it, because now they can't do nothing with it, so they don't have to pay taxes. Well, who really benefited that? It's not an even playing field. It's a landowner next door that has to pay taxes because he still has the possibility to use his property, but I don't know. That's a big question I have about it.
Okay, Richard.
It's the vast majority of these conservation easements are done by private treaty, whether it's Ducks Unlimited, Jackson Hole Land Trust. The one exception is BLM, which is federal government, and it is a very useful, functional tool in our system, and it's done on a private basis for the most part, excluding BLM. And just like any right that you have or don't have or decide to sell, it can affect the value up or down. And if I sell my development rights to Bruce Simon and I can only build one, justifiably it reduces the value, therefore I have to pay less tax. It's a very valuable tool that's, when it's used in the private sector, it works very well. Yeah,
and if I didn't express that, Hort, I think I may have expressed that incorrectly. If there's a private negotiation with private land, that's America. When government gets involved, I think that's where there's a challenge in general.
But the whole point is if the use is an actual value, and they're saying you can't do that any longer, well, they don't have to pay taxes on it but yet they should, because in essence they're separating the use from the land, and the land is taxed at a lower rate. But the idea that you've got something of value to sell, then there should be something of value that should be taxed. Okay.
Note to self, don't bring up in a presentation something you don't know a lot about. I was simply trying to say, in general, private agreements are awesome, and when the government gets involved.
Well, you're in a county that it's on the forefront of everybody's mind because they're stepping over so many boundaries, and the idea of conservation easement goes against the Constitution, I believe, but I don't know that much about it. That's why I'm here to ask you, actually.
Well, unfortunately, I'm in the same camp. I don't know much about conservation easements.
I think many constitutional scholars believe that the beauty of the Constitution is some of the words like just compensation, needful buildings. This is much deeper than semantics. These are very, very glaring words, you know, that leave out. I mean, you know, very simple. A fort is a fort. A magazine is a magazine. A dockyard is a dockyard. But needful building.
It's subjective.
Has given the ... Just compensation has given the fill in the blank. And the Constitution is full of these. And so that's, you know, many people believe that's sort of the essence of the Constitution. And that's the thing that really causes so many problems now. But
yeah, that's interesting. And then what governs should be the morality and virtue of the people, shouldn't it? Instead of them throwing out every little thing and saying you can and can't do this. No amount of rules are going to make someone moral or virtuous. Okay, like I said, next time I'm not going to bring that up. All right, let's take a quick break. We're about an hour into it. Quick 5-minute break, and then we'll come back and we'll finish it up. And we're gonna get into the Jackson Hole or the Teton County comp plan, so don't miss it.
If anybody needs pen